Be recognized.
Senator Cornyn.
Mr. Chairman, I'd like to call up my amendment OLL 23707. This would extend the right to carry a firearm to federal judges so they can protect themselves. Many of us, back in Texas and also here in D.C., have gone through the process of getting a concealed firearms license because I'm concerned, particularly with the increasing crime and attacks against public officials and threats against public officials, that they need to be in a position to defend themselves should they choose to do so. We've already talked about the high-profile threats and attempted attacks against Justice Kavanaugh, but of course, we know there's also been a recent killing of a retired Wisconsin state court judge, John Romer, by a criminal who'd previously sentenced him. And of course, we've also considered the tragic death of Judge Salas's son in 2020. So I've heard from a lot of judges, not just on the Supreme Court, but across the country, who are reporting more and more threats of violence against them. Judges should be able to protect themselves and their lives and their family members anytime, anywhere, whether or not a police officer answers a 911 call on a timely basis. So my amendment would allow those federal judges who choose to do so the authority to, along the same terms as qualified law enforcement officers do now. This is particularly important as federal judges go to and from their federal courthouse, travel, or even run errands in their neighborhood. I urge my colleagues to support the amendment.
Thank you, Senator Cornyn. As I understand it, there's nothing to stop a federal judge from carrying a gun now other than state and local law. And I don't know if this is an attempt to exempt
There's nothing to stop them other than state law or federal law?
State and local that I can think of.
So well, the point is this would make it under federal law, which would preempt restrictions at the state and local level.
Does that require a training course?
That's voluntary by the judge.
Well, it raises some
They're
questions.
trained sportsmen. They've been raised their whole life using firearms. They know how to do so safely and store them appropriately. I think if we trust them with our Constitution, we should trust them with a firearm to defend themselves.
Nothing under current law that prohibits a federal judge from applying for a concealed carry permit wherever he happens to reside. Nothing. I don't know if this is a federal preemption of state requirements on training, and each state has a different approach to this, but I certainly wonder why we would take this up at this moment when we're considering protecting the reputation of the court. I would
Well, because of the overt attacks by the Majority Leader of the United States Senate and others. I mean, Mr. Chairman, you pointed out appropriately so, we have responded with additional resources for law enforcement.
And we will continue to.
For the members of the court. And I asked Senator Lee because I wasn't sure that was the case, but apparently there are protective details available to the justices now, but historically that's not been true. They've been basically on their own or on an ad hoc basis when they've requested the U.S. Marshal Service to provide them assistance. But the premise that the Supreme Court, like many other public officials, are subject to threats and potential attacks against their person or their families, I don't think is in doubt.
Anyone else seek recognition on this amendment? If not, the clerk will call the roll.
Mr. Chairman.
Senator Hirono.
Mr. Chairman, this amendment, like the previous amendment, are among a number of amendments, over 60, filed by our Republican colleagues on this committee, which has nothing, as far as I can see, to do with a code of ethics for the Supreme Court. So now suddenly we're dealing with an amendment that would allow justices or judges to carry guns. What does that have to do with a code of ethics for the Supreme Court? I have to say that sitting here listening to my Republican colleagues malign our motives as to what we are attempting to do with something, as I thought, as common sense, as requiring the Supreme Court to abide by a code of ethics as all of our other judiciary members have to abide by. What is so hard to understand about that? In the meantime, I see there are other amendments that have to do with our code of ethics, the executive branch behavior, members of the Judiciary Committee. I don't know what that has got to do with the matter and the bill before us. So I'd just like to say that, in addition to what I've already said, first of all, it is not productive to question really the motives of those of us who sit here and who are saying that the highest court in the land should be setting an example in terms of abiding by a code of ethics. So we do not often see sitting judges, weighing in on the need for the Supreme Court to have a code of ethics. So I would like to ask unanimous consent to have Judge Michael Ponzer's article. It was a guest essay in the New York Times dated July 14th, 2023. And when she says, he asks, does the Supreme Court realize how bad it smells? And in the context of the various disclosures, that raises a lot of eyebrows, free private airplane travel, payment of tuition. And yes, this applies to Republican and Democratic nominated Supreme Court justices. So in the end of his article, he says, although the exact numbers fluctuate because of vacancies, the core of our federal judiciary comprises roughly 540 magistrate judges, 670 district judges, 180 appeals court judges, and 9 Supreme Court justices, fewer than 1,500 men and women in a country more than 330 million people and 3.8 million square miles. And much depends on the small cohort's accurate sense of smell, its instinctive, uncompromising integrity, and its appearance of integrity.
Mr. Chairman?
So I will be voting against this and other amendments that have nothing to do with what is before us, which is Code of Ethics for the Supreme Court.
Without objection, the article referred to by Senator Hirono will be added to the record. Senator Graham?
Yeah, Mr. Chairman, I'd like to respond to my colleague from Hawaii. The point we're trying to make is that we're not questioning motives. We're reading what you said. We're putting this in context of a broader picture. The majority leader of the United States Senate went to the steps of the Supreme Court and threatened him as much as you can literally threaten somebody. There's been an effort on your side to expand the Supreme Court, to do away with the conservative majority. So there's a pattern here of trying to diminish, demonize, and neuter the court. I don't know if you've read the bill you're supporting, but this bill is a complete frontal assault on how the court operates by congressional statute. It creates a system that Senator Lee described that would make it very easy to make an allegation of a conflict of interest and have a panel of judges, not the individual judge, decide the merits of this. It fundamentally changes the recusal system. At the end of the day, I think it is literally a remaking of the court designed to dilute the power that exists today of the Supreme Court for political purposes. And this can't be viewed in isolation. Justice Ginsburg, a lot of Americans admire, including me. She got $1 million. I'm not suggesting she took the money. I think she gave it away, but she won't tell us who she gave it away to. And they still won't.
Mr. Chairman.
She signed an opinion, the Virginia Miller Institute VMI case about women going to state-supported schools. She signed a copy of that opinion to be auctioned off by the National Organization of Women's Legal Defense Fund. So all I'm saying, and the court travels everywhere. I have not bored this committee with the travel schedule of all the justices during the summer, and I don't begrudge them for doing that. I wish I could go to some of these places. The bottom line is, I'm not begrudging that. You are trying to destroy this court, and this bill is part of a process. So yes, we view this in a broader context. These amendments have everything to do about protecting the court. Millions of Americans watched on television an organized effort to go to Supreme Court justices' homes for the desired purpose of ruining their lives, intimidating their families, and not a damn thing happened about it. Yes, that is, to me, relevant. Whether a judge should carry a gun or not, if they want to, they should. The bottom line
Chairman.
here is this is relevant. And we will look at this in a broader perspective. And that perspective, I think we've tried to articulate pretty well. A concerted effort been going on for years to marginalize and destroy this court.
Mr. Chairman,
Senator Hono, and then we'll call the vote.
since my colleague is directly addressing me, I would like to say that if there's anybody that's been spending decades trying to put onto the Supreme Court the kind of people who have an ideological agenda, I would say that it is the very judges or justices that my colleague is supporting. So again, I say that we are confronted with a Supreme Court that in terms of recusal, for example, they get to decide individually whether or not they will recuse themselves. How is it that you can have a Supreme Court justice who does not recuse himself when his wife is involved in the very issue that is before him? I would say that those kinds of examples really raise the question of why shouldn't the Supreme Court have a code of ethics as those kinds of provisions apply to everybody else. And by the way, we have a code of ethics in the Senate. This is our code of ethics, Senate Code of Ethics. Why shouldn't the Supreme Court, which is the highest court in the land, and when you talk about intimidating the court, how do you intimidate the court that gets to decide cases and reverse cases that are decades-long decisions, and there's nothing we can do about it? So please, the constant refrain of citing to the majority leader is, as in my view, it's not very compelling. What is compelling is the need for the Supreme Court to have a code of ethics. Thank you, Mr. Chairman. Let's get to the vote.
Senator Cornyn,
Mr. Chairman, I would just direct the senator from Hawaii to the United States Court's website, which has a code of conduct for U.S. judges. You said they don't have a code of conduct and they need one, and so the Congress has to impose it on them. That's just factually incorrect. And the senator's question, what's the relevance of providing a judge an opportunity to defend themselves and their family? What's the relevance of that to the longstanding campaign of intimidation and harassment recently rising to the crest of the majority leader threatening two members of the court by name? You know, what's the relevance of self-defense to that? Well, it is because there are unstable minds out there who, when they see public officials accusing the members of the court of wrongful conduct, they will respond to that. And thank goodness, in the case of Justice Kavanaugh, law enforcement was able to interdict the individual who intended to kill him. So I think Justice Kavanaugh and every judge ought to have the ability to defend themselves if other defenses are not available. And it's directly related to the campaign of intimidation, harassment, and the attempt to politicize the court.
Mr. Chairman, I'd like to make
question is on the, Senator Lee.
Yeah, as to the recusal standard, yeah, they make that decision. That is how that works. It's how it's always worked. It's how it should work. It's no different in that regard from what we have in the United States Senate. We also have the decision up to us as to whether to recuse. The difference is there's no legal expectation or requirement that we do so. They do have one. Thank you.
Questions on the adoption of the